First Amendment to the United States Constitution actually generally protects what many people would consider to be hate speech. The United States Supreme Court has carved out from First Amendment protection of free speech a number of different categories of speech that are simply not protected. So for instance, examples of unprotected categories include true threats of violence, fighting words, obscenity, and child pornography. But the United States Supreme Court has never carved out an unprotected category of speech called hate speech. In order for hate speech to not be protected under the First Amendment, the use of that language would have to fall within another existing non-protected category. One of the interesting things that most people don't understand about the First Amendment is that it only protects against government censorship, not censorship by private entities, such as social media platforms like Twitter or Facebook. So when Twitter and Facebook choose to remove content from their websites or their platforms, that does not actually raise a First Amendment issue, because the First Amendment only protects us from government censorship, not censorship by private entities. The United States Supreme Court, in a case called Alvarez versus the United States, struck down a law that banned lying about having won a Congressional Medal of Honor. Many people have viewed that decision very broadly and say, oh, that gives us the protection to lie and to say anything we want. Actually, the decision was rather limited. What the court focused on was that these were simply lies in the air without any tangible harm connected to them. So if you can say that there's false speech and then you can connect it to a tangible actual injury caused by that false speech, then it's not going to be protected. I think that censorship by the government is probably the most damaging thing, especially from a First Amendment perspective. In the United States, we've traditionally existed under a marketplace of ideas model of free speech, in which all ideas, no matter how offensive or disagreeable they may be, come out and fight freely and fairly. The problem today with the marketplace of ideas metaphor for protecting speech is that a number of individuals, and by that I mean actually large corporations, actually control much of the marketplace of ideas. They have greater access to it, they have a louder voice in the marketplace of ideas, and they can skew it to their perspective. So increasingly what we see is a call for the government to intervene and to adopt laws that would restrict false information that is circulating in the marketplace of ideas. That notion that the government should come in and protect us kind of smacks of paternalism in a way, that we need the government to sort out for us what's true and what's false. The question of judicial activism versus historicism or original intent is always very prominent, especially when we have the confirmation hearings for nominees, such as in this case, the future Justice Barrett in this case. So when we have that, what that really raises are questions, the larger questions being tapped into there is separation of powers and the proper role of the judiciary versus the proper role of the legislative branch. The other thing that people need to understand about the First Amendment is that it's a viewpoint neutral document. It says Congress shall make no law abridging freedom of speech or the press. It doesn't say good speech or bad speech, Republican speech or Democratic speech. The government, in other words, must remain neutral when it comes to private speech, the speech of individuals in terms of censoring.